this session on the impact of criminalization of non-disclosure of HIV on women in Canada. We plan to be probably done in an hour or so. We actually have the room booked until 1:30 so that people can stay and engage in conversation with the speakers. So if you don't have a class immediately after and there's still food around, you should probably stay and use that opportunity to chat with the speakers. We're expecting more people here today, but I know given the weather and all of the things like exams, etc., we've had a few cancellations. But what we're going to do is actually record today's session in order to put it into the form of a podcast and make it available to more people who are interested in the content but can't be here. So my name is Jackie Gahagan. I'm a professor of health promotion here at Dal in the School of Health and Human Performance. I'm also the director of the Gender and Health Promotion Studies Unit here at Dal. And I'm very pleased to welcome you to this Lunch and Learn. We've got a great lineup of speakers. We've got some very interesting perspectives from health promotion. That would be me speaking to that. And we also have public health being represented by Michelle Proctor-Simms, who is the director of the Nova Scotia Advisory Commission on AIDS. And we also have a legal perspective being presented by Elaine Craig, who is a professor here in the law school at Dal. And each speaker will do a brief intro to what they're talking about, so I won't get into that at this point. Right, so this room is not super conducive to being an engaging, informal sort of atmosphere, but we're hoping, despite the fact that you can't really move the furniture around, that people will engage with the speakers. Because we're recording it, what I would ask is if you've got questions at the end of each of the talks, please feel free to ask those questions at that point. Otherwise, if you want to wait until the end, we're going to shut off the recorder and then people can engage more fully in an open conversation. At the end of the presentations, Constance will be giving you a little bit of a wrap-up of what we heard today. She's also going to encourage you to get involved in our next event, which is going to be held in conjunction with International Women's Day at the Art Gallery of Nova Scotia. So if you kind of like the flavor of what you're seeing here today, the hope is Constance will be able to encourage you to get involved in our next event. We've got plenty of time to prepare, but it's not until March. I'd like to thank our presenters, Michelle, Elaine, and our sponsors for this event. There's a lot of wonderful sponsors who came forward to participate in making this event happen. So thank you to the Health Law Institute and Constance in particular for her support. Also the School of Health and Human Performance, who made in part the lunch available to you, as well as Constance from the Health Law Institute. So thank you for that. Thank you to Alex. Hi, Alex. Alex is my research manager. She actually is really integral in keeping my program of research moving over at the Gender and Health Promotion Studies Unit. So thank you, Alex, for always doing everything that you do well above and beyond. Thank you also to Michelle and Maria, who are here from the coalition. I'm not sure that, you're staying till 1:30, yes? Okay, so if people have questions that they would like to ask specifically of Michelle and Maria, please do. They've also kindly brought all kinds of materials for you to read and to take away. So you'll see there's a package of material at your desk, so please feel free to take those with you. And if you've got questions about the content of any of that material, please get in touch with Maria McIntosh. She's actually the ED, and she would be happy as well if you would fill out the evaluation forms at the end of this session, and please leave those on the table with the other materials you can take with you.
We love data.
Okay. So can I just snuggle in?
Yeah, definitely. Snuggle in.
Okay. So by way of introduction, I just want to give you a little bit of background in terms of how I'm going to frame my comments. So essentially, I've been involved in the HIV/AIDS movement since the late 80s, particularly as a community activist, as a health researcher, and more recently as a policy advisor. And in fact, I serve as a policy advisor to the Federal Minister of Health on HIV issues in Canada and internationally. So it's been some 30 years that we've been grappling with this pandemic, and yet several key themes remain fixtures on the prevention landscape. For instance, discrimination, stigma, fear, denial, and silence, to name just a few. As the pandemic shifted from looking at soaring infection rates among gay men in the early days to more and more women becoming infected, we see how the gendered impact of HIV/AIDS plays out in the lives of men and women across this country. We've witnessed the gender divide in terms of participation rates in clinical trials, where women were often excluded from clinical trials in the early days, in terms of access to gender-sensitive care, treatment, and support, and the enduring legacy of the differential access to condoms, both male and female condoms, and other prevention interventions. So from a health promotion perspective, I remain hopeful and yet at times extremely frustrated at our collective inability to get ahead of the spread of this virus. We have long since known how the virus is spread. We already know that. So if we know that, why are we so slow to look at context of risk? So rather than focusing and fixating on individual behaviors, why are we not looking at this broader context? So we know that despite the fact that we have access to antiretrovirals in Canada and elsewhere in the world, although access is quite variable, advances in treatment are not necessarily the solution. So just to give you an example, although advances in medical treatment are incredibly important, and so through the use of things such as antiretroviral therapy, we've been able to actually extend the life of people living with HIV. I'm not telling you anything that you don't know. So what that means then is that we can actually reduce people's viral load to be undetectable, right? And so that's the good news. So people living with HIV can take antiretroviral therapy, and if they're able to adhere, they can reduce their viral load. So this is an important advancement in HIV medical treatment. I would argue that it is promising in terms of reducing the spread of infection, and that's an important issue to keep in mind in terms of this discussion today. However, such treatments are not without their challenges. They are not the so-called magic bullet, and that they will not lead to a cure. They will not remove HIV from a person's bloodstream, but they do allow people to live with HIV longer without experiencing AIDS-related opportunistic infections like Kaposi's sarcoma or PCP pneumonia. We are, however, seeing more comorbid conditions among those living with HIV, and the question remains, how much of this is related to advanced aging due to HIV infection, or how much of this is due to long-term use of antiretroviral therapy, or both factors combined? Okay, so what does this have to do with health promotion? The little hub of health promotion people are thinking. So, according to the World Health Organization, health promotion is the process of enabling people and communities to increase control over and to improve their health. Health promotion as a discipline does this through adhering to the principles of the Ottawa Charter for Health, i.e. building healthy public policy, creating supportive environments, strengthening community action, and reorienting health services, as well as addressing the underlying social determinants of health through lobbying, advocacy, and through sound health and social policy development. Further, health promotion aims to move beyond the focus on individual behavior towards a wide range of social determinants and environmental factors that impact on health and health outcomes. Health promotion interventions are therefore aimed at addressing both structural determinants of health that extend beyond the individualistic so-called lifestyle choices. We know that without addressing these broader determinants of health, that our policies and programs, etc., will not be particularly effective, and at worst can contribute to poor health outcomes and premature death. This is particularly salient in the case of HIV, in that unlike other health issues, HIV comes with a long history of stigma, discrimination, denial, and othering. In addition, we have seen the gendering and differential impact of HIV on the lives of men and women in this country, and I would argue very, very poignantly at the international level. Bless you, Tammy. In attempting to mitigate the impact of HIV, upstream approaches, including both primary and secondary prevention of HIV, have remained core elements to the health promotion HIV policies and programs related to interventions. HIV testing has been regarded as an integral part of this upstream prevention approach. in that knowing one's HIV status can, 1, help facilitate timely access to health care if found to be HIV positive, and 2, with the knowledge of one's HIV status, greater awareness can help keep negative individuals negative, and where found to be positive, prevent the onward transmission of the virus. Or so the logic goes. On the plus side, health promotion's primary prevention focus on upstream prevention interventions in order to develop long-term sustainable HIV responses through strengthening health systems and community systems while tackling determinants of health, including gender, I would argue, as a key determinant of health, can collectively leverage support for anti-poverty programs, affordable housing campaigns, etc., which we know have a collective impact on people's health outcomes. So these determinants, such as gender or socioeconomic status, are responsible for both driving the epidemic and hindering our collective response. For example, we know that gender-based sexual and reproductive norms can serve to shape individual and community-level responses to the spread of HIV. Sexual and reproductive autonomy is gendered, often creating tensions in decision-making regarding issues such as condom use between male and female sexual partners. So from an upstream primary prevention health promotion perspective, criminalizing HIV non-disclosure has a very real potential to shut down the conversation about knowing your HIV status, about getting tested for HIV, about talking to sexual partners or healthcare providers about HIV. This is not, I would argue, good health promotion. This is simply adding to the potential of gender-based violence against women, of increased levels of incarceration, and of poorer health outcomes for women in Canada. Such a punitive approach is not in keeping with the core principles of health promotion. So in conclusion then, from a health promotion perspective, criminalization of HIV non-disclosure may serve to yield very detrimental impacts in the following ways. 1, it will reduce testing uptake rates, particularly among women who fear gender-based violence in asking male partners to use condoms. 2, it will do nothing in terms of the onward transmission of the virus if individuals remain fearful of disclosing. And 3, it may not assist in equalizing the economic burden, the caregiving burden, the social stigma burden faced by women in determining whether or not they should disclose the fact that they're living with HIV. I would argue we can do more and we can do better in our health promotion efforts through policy and programmatic responses that address risk contexts, that advocate for structural changes in society, and that move away from punitive responses to a health and social issue such as HIV. Protecting and promoting human rights, and more specifically, promoting gender equity are, I would argue, essential elements in the health promotion response in Canada, particularly in light of the Supreme Court decision on criminalization of non-disclosure. Thank you.
Thank you. So that's a good segue into what I want to talk about, which is in part this most recent decision by the Supreme Court. Let me just say thank you, first of all, to all of you for coming, and thank you to Constance for giving me the opportunity to talk to you for a few minutes today. So my objective is to give you just a brief overview of the legal context regarding the criminalization of non-disclosure as it stands today. And so in particular, that'll mean talking about 2 cases, or really 3 cases, I guess. Courier, which is a decision released by the Supreme Court of Canada in 1998, and it's important to pay attention to the dates in terms of this issue. And then Maybeer and DC, which were released by the Supreme Court of Canada just this October, so last month. Before I start kind of discussing these cases and the legal implications of them, let me start by prefacing my comments with the context. So Canada has one of the highest rates of prosecution for the non-disclosure of HIV status to one's sexual partners of any developed country in the world. So not only are the rates of prosecution higher in Canada than in countries like the United Kingdom and Australia, but the types of charges laid in Canada, the nature of the offence that people are charged with is more serious. So in other words, we criminalize the non-disclosure of HIV status to one's sexual partners in a much more aggressive fashion than do other sort of like-natured jurisdictions around the world. Okay, so the framework for the current criminal law approach to this issue was adopted by the court in 1998 in a decision called Courier, which I suspect many of you are familiar with. And Courier, despite what happened in these most recent cases, remains the leading precedent in Canada in terms of the criminal law approach to nondisclosure. Courier concluded that there is a duty to disclose to sexual partners any significant risk of serious bodily harm. That's the test laid down in Courier. Failure to disclose significant risk of serious bodily harm, said the court, will vitiate consent to sexual intercourse. Vitiate consent means make defective, right? So make otherwise consensual sexual contact non-consensual. It creates a legal rule that defines sex in these particular types of circumstances of nondisclosure as sexual assault. So Courier established that the current criminal law approach in Canada to the nondisclosure of HIV to one's sexual partners is going to be based on the sexual assault provisions in our criminal code. So assault, sexual assault causing bodily harm, and aggravated sexual assault, which is, of course, our three-tiered approach with aggravated sexual assault at the top. And what they did was create this kind of two-part test to determine whether consent will be vitiated in a particular case. So you have to have two things, said the court. You've got to have proof of dishonesty, which is established by a failure to disclose one's HIV positive status, and either a deprivation or a risk of deprivation. And what that means, they say, is either proof of harm to the sexual partner or a significant risk of harm. And that's important to pay attention to, that one can be convicted of sexual assault, or more likely aggravated sexual assault, where one exposes someone to even the risk of transmission. It's important because what that means, of course, is that you don't need transmission of the virus in order to convict someone of these serious criminal code offenses. It's just the risk of transmission that is sufficient. And in most of the prosecutions that occur, transmission hasn't occurred. Another important point to draw from Courier is that the majority in Courier suggested that wearing a condom would likely reduce the risk such that non-disclosed sex, as I'll call it, with a condom wouldn't vitiate consent. Courier was decided in 1998, and as the folks sitting up here with me today will be able to speak to in a much more detailed way than I can, the medical context, of course, today is significantly different than it was in 1998. So that in Courier, the court didn't even talk about viral loads and viral load testing, for example. So viral load testing, of course, measures the amount of HIV genetic material in a bodily fluid, and there's a direct relationship between one's viral load and risk of transmission. And that's important because in the post-Courier years, some courts, particularly more recently, began to recognize that deciding whether or not an instance of non-disclosure actually constituted a significant risk of serious bodily harm required taking into consideration, in some cases, one's viral load. Because, of course, the lower the viral load, the less likely transmission is to occur, and the test in Courier sort of sets a bar, right? That you're only going to have consent vitiated in circumstances where there's a significant risk. So this, of course, created a legal context in which the court had to begin to struggle with what constitutes a significant risk, right? There are a number of problems with the approach to non-disclosure that was adopted in Courier. One is around the issue of viral load. Courier created uncertainty in the law. It put courts in the position of having to ascertain, what constitutes a significant risk. It put courts in the position of having to receive and weigh, expert medical evidence on the relationship between, viral load, the number of sexual interactions, condom use, proper condom use, all of these kinds of factors, factual factors. It also has, I would argue, resulted in overcriminalization, which I've kind of referred to a little bit, but I'll talk a little bit more about that in a moment. It's also it's related, or it's resulted in a problematic, I think, reliance on expert medical evidence, which creates burdens for people that are accused of sexual assault for failure to disclose. And as we'll see in a moment when I talk about D.C., which was one of the cases released last month, it's established a legal context or approach that has no capacity for a contextual analysis. And that, I think, is not good for women. And so that was kind of the legal landscape. That's where things stood post-Courier. And that's where things stood when these most recent cases of Mabior and D.C. Worked their way up to the Supreme Court of Canada and ultimately were decided just last month. So in this most recent decision, and Mabior and D.C. were decided at the same time, they're what we call companion cases. And so the court established or clarified the legal test in Mabior and then just applied it in D.C. And I'll talk more about that in a moment. But the court purported to respond to what had been identified as some of these problems with the legal approach adopted in Courier. Unfortunately, what the court did, I think, in Mabior was not only not resolve these problems, but actually likely make some of these difficulties even worse. And it is, in that sense, quite a conservative decision. So I'll talk quickly about two things. One is that I'll just kind of walk you through Mabior and D.C. and then talk a little bit more about what some of the problems with this outcome are from a legal perspective. So Mabior involved an accused who had engaged in repeated acts of protected and unprotected sexual intercourse with a series of different women, women who were described as at-risk youth, one of whom was as young as 12, I think, without disclosing to any of them that he was HIV positive. And he was charged with 9 counts of aggravated sexual assault. With some of them, and with respect to some of the sexual interactions, he did use a condom. Sometimes he didn't use a condom. None of the women contracted HIV, and he was at trial convicted of 6 counts of aggravated sexual assault. The Manitoba Court of Appeal overturned some of Mabior's convictions on the basis that, with respect to some of the sexual interactions, his viral load was so low that the risk of transmission was so small that it couldn't be said that he had exposed these women to a significant risk of serious bodily harm. Or he had properly used a condom, or he had properly used a condom such that the risk was sufficiently negated. So the implication of what the court did what the Manitoba Court of Appeal did in Mabior was to create an interpretation of Courier, an application of Courier that said where the viral load is undetectable or low, such that the risk, based on the medical evidence, is significantly reduced, or where proper condom use occurred, the significant risk of harm, such as is required in Courier, is negated. Okay, so low viral load or condom use, according to the Manitoba Court of Appeal, will or should result, in most circumstances, in an acquittal. Okay. The Supreme Court of Canada did not agree with the Manitoba Court of Appeal. This is Mabior. Okay, this is the case from last month. They concluded that, first of all, that the test in Courier is okay, that it doesn't create the kind of uncertainty that some of its critics suggested, that it is workable. They restored Maybier's convictions. They restored Maybier's convictions, so they overturned some of the acquittals ordered by the Manitoba Court of Appeal, and provided some legal language for us as to what will constitute a significant risk of serious bodily harm. So what they said is a significant risk of serious bodily harm means a realistic possibility of HIV transmission, okay? So they decided, so then of course, as we do in law, you then have to interpret what that means. And what they did is they said a realistic possibility of HIV transmission means that, as a general matter, what this means is that a realistic possibility of HIV transmission will be negated where the accused's viral load was low and a condom was used. Okay, so in other words, unless a condom was used, consent is vitiated. Okay, you have to have a condom, and even if a condom is used, consent will still be vitiated where the viral load is something other than low. Okay, meaning you can be convicted of aggravated sexual assault according to Maybier, even if your viral load is low, such that the chances of transmission are, infinitesimally small, but you didn't use a condom. And you can be convicted, even if you do use a condom, if your viral load is something other than low. So you have to both use a condom and have a viral load that's low in order to avoid conviction. This is more aggressive than Courier. What it means that in a case like DC, which was the companion case released the same day as Maybier, that the accused woman, which I'll talk about a little bit more in a moment, would have been convicted of aggravated sexual assault if there hadn't been a problem with the finding of fact at trial about whether she was whether the complainant was wearing a condom. Okay, so in other words, this companion case, which is really kind of facts that are significantly different than what you're dealing with in Maybier, they only upheld her acquittal because at trial the Crown didn't properly prove beyond reasonable doubt that a condom wasn't used. Okay, so what happened in D.C.? D.C. involved an accused woman who did not notify the complainant of her HIV positive status before their first sexual encounter, which was allegedly unprotected. And that was the point of the factual point that was in dispute on appeal. Subsequent to this first sexual interaction, she disclosed her status to the complainant a couple of weeks later. They then engaged in a long-term relationship involving both protected and unprotected sex for a number of years. After a number of years, they had a tumultuous breakup in which the complainant assaulted her and was convicted of assault. And after this happened, after he was convicted of assaulting her during their sort of breakup or the breakdown of the relationship, he filed a complaint against her regarding the single act of unprotected sex several years prior. And D.C. was convicted at trial of aggravated sexual assault. The Quebec Court of Appeal overturned her conviction on the basis that, while the Quebec Court of Appeal accepted the trial judge's finding of fact that a condom had not been used, but found that there wasn't a significant risk of serious bodily harm because her viral load was undetectable, such that the risk of transmission was, none or infinitesimally small. Post-Maybier, on the same facts, so assuming that in DC a condom hadn't been used, but she had an undetectable viral load, on the same facts, DC would have been convicted had it not been for this factual problem around the use of a condom. Okay, so what are the implications of this decision? This decision by the court in Maybier to both uphold the test in Courier and interpret the test in Courier to say, to negate the significant risk of serious bodily harm, you have to both have a condom and a low viral load. One of the implications of this decision is the continuation of a law that has no ability to differentiate cases based on context, so that under the current approach, there is no way to apply the law differently as between Maybier and DC. There's no way to apply the law differently as between a man who engaged in sexual conduct, sexual intercourse, repeated acts of undisclosed and sometimes unprotected sex with a number of at-risk youth, and a woman who had one act of unprotected sex followed by disclosure, followed by a long, intimate relationship in which there were issues of domestic abuse. Both of them, under the law as established in Maybier, are subject to liability for aggravated sexual assault. There's no recognition of the gendered power differentials that make negotiating for protected sex different for men and women. There's no possibility for contextual analysis. A second result of this decision will be continued overcharging. So, because of the wording of the test established in Courier, a significant risk of serious bodily harm, and the wording of the criminal code provision establishing the offense of aggravated sexual assault, because the wording matches up for those two, this means that in most cases, the Crown lays charges of aggravated sexual assault rather than sexual assault or just assault. Okay? Aggravated sexual assault is, of course, the third tier of our sexual offense provisions. It is the most serious type of sexual offense, and it is one of the highest stigma offenses under the criminal code. It exposes those convicted of it to the possibility of a sentence of a life sentence of imprisonment. It is, but for homicide, perhaps the most, certainly one of the highest stigma offenses. Outside of the context of non-disclosure of HIV positive status, people are typically only convicted of aggravated sexual assault where you have non-consensual sexual touching combined with the kind of acts that we might consider torture. So it is a very serious offense. And in Canada, unlike in other jurisdictions like the United Kingdom or Australia, this same charge of aggravated sexual assault is used regardless of the type of activity, regardless of whether transmission occurs, regardless of the number of acts of undisclosed sex, regardless of the nature of the deception, and like I said, the rate of prosecution is significantly higher. We would have to be comparing ourselves to the United States in this criminal context, which is something that ought to not sit well. Okay, we don't want to be in that club when we're talking criminal law. So obviously a legal response to non-disclosure of HIV positive status that consistently charges people, consistently involves the very most serious sexual offense under the criminal code, risks further stigmatizing individuals living with HIV/AIDS. Maybier has done nothing to alleviate this. It will likely worsen the situation because we did have some lower courts that were refusing to convict in circumstances where you had an undetectable viral load or a condom. So instead of an and test, we used to have an or test. The burden on defense of leading expert medical evidence on viral load has not been alleviated by Maybier. An acquittal will require a defendant to rebut evidence of viral load something other than low, and the lack of gendered contextual analysis post-Maybeer persists.
Okay, good afternoon, everybody. My name is Michelle Proctor-Simms. I am the director with the Nova Scotia Advisory Commission on AIDS. I have been the director for the last 4 years, and previous to that, I was a research officer, and I joined the commission in April of 2000. So I've been around for a little while. And for those of you who don't know, the AIDS Commission is an arm's-length agency of the provincial government. It was established in 1989 to advise the government on matters related to HIV and AIDS and its impact on Nova Scotians. And since 2003, we've been the coordinating agency for the provincial strategy, Nova Scotia strategy on HIV/AIDS. As Jackie indicated at the beginning, I'm going to speak to the public health perspective around this issue. I do want to make an important disclaimer, though. Given that I am arm's length with my role in the Commission, I don't work directly within the formal public health system, so I just want to say that my remarks are my own, based upon my own knowledge and expertise and the research that I've done to prepare for this. And I know there are people in the audience who do work in the formal public health system, so please feel free if I've made any factual errors or anything like that, and in fact, add to my remarks. Okay, so I will begin by defining what public health is. Public health is the art and science of creating and assuring the conditions for people to be healthy through the organized efforts of society. The essential functions of public health are generally considered to be population health assessment and surveillance to inform decision-making, prevent illness, injury, and disease, health promotion, and health protection. It focuses on the health of communities and populations rather than the health of individuals. As individual health. It's a formal primary responsibility of governments, and it employs a range of population-directed activities, including public health legislation and policy, and related to controlling the spread of communicable diseases. In Nova Scotia, we have our Health Protection Act, formerly called an Act to Provide for the Protection of Health. It provides the legal framework enabling public health officials to protect the public and to prevent, detect, manage, and contain health threats without unduly interfering with civil rights and liberties. It deals with notifiable diseases or conditions, communicable diseases, health hazards, public health emergencies, and food safety. And it lays out the responsibilities and duties of public health officials and of the ministers responsible. It has accompanying regulations and policy, for instance, regulations for the reporting of notifiable disease and conditions, supported by our surveillance guidelines, as well as regulations for communicable disease, with guidance from Nova Scotia's Communicable Disease Manual. Public health legislation and policies, such as Nova Scotia's Health Protection Act, prescribe a continuum of interventions and powers that are possessed by public health officials to compel people and organizations to take certain actions to protect the community from a public health threat, These interventions range from voluntary measures such as voluntary counseling and testing for sexually transmitted or bloodborne infections, including HIV, access to prevention tools and equipment such as clean needles, partner notification, intensive counseling, support and linkages to services, to increasingly coercive measures such as mandatory reporting of cases, behavior orders, examination, testing, treatment by a healthcare provider, isolation and detention, court enforcement of public health order backed by the force of law, and offenses and penalties. Through all these, there's a careful balancing act of individual rights and the public good. So given this legal framework, situations involving non-disclosure of HIV status is best addressed by the public health system, because it takes into what Elaine was getting to, allows for that contextual analysis. The criminal justice system is just not equipped to deal with the complexity of HIV and AIDS. A public health approach, rather than seeking punishment, is more likely to protect the health and individual rights concerning HIV/AIDS by seeking to understand why some people living with HIV/AIDS do not disclose, taking into account their specific real-life challenges and circumstances. It also provides access to a range of appropriate services and supports, focusing the interventions on the actual risk posed by the individual. If these measures do not work, public health officials are able to use more coercive measures up to and including apprehension and detention. In my view, use of the criminal law is at best redundant. Unfortunately, the October 5th ruling that Elaine was referring to, rather than clarifying what constituted significant risk of exposure to HIV based on current scientific information about actual risk, has actually made non-disclosure a criminal offense no matter how small the risk, with the exception of when an accused used a condom and had a low viral load, as Elaine has already indicated. And I think it's worth repeating some of the harms that will come out, that will likely result. First of all, it discourages testing for HIV and other sexually transmitted bloodborne infections, and it also from seeking other related treatment, care, and support services. This flies in the face of public health messaging to know your status, especially at a time when 25% of Canadians are estimated to not know they're HIV positive. And of course, testing is the gateway to care, treatment, and support. Second, it gives the impression that condoms and antiretroviral treatment on their own, in their own right, are not good enough. And it also creates a false sense of security that safer sex or condom use are not necessary if your partner does not disclose. Again, this flies in the face of public health messaging about safer sex, taking responsibility for one's sexual health, and the effectiveness of condoms. I also fear that it will lead to some people living with HIV, when they become diagnosed, to begin treatment before they actually clinically need to do so. And finally, it reinforces the significant and prevailing HIV stigma and discrimination, making an environment of disclosing your status even more difficult and even more safe. These harms are quite significant to historically oppressed and marginalized women and otherwise living in adverse circumstances. The October 5th ruling and the Courier decision has been touted as a tool to protect women from HIV infection and violence, as well as enhance their dignity and autonomy in relation to sexual decision-making. But it actually makes women, especially those living with HIV, more at risk. This is because many women are not able to make autonomous decisions about having sex and using protection. Therefore, they cannot control risk. Women are often judged more harshly in these situations. Also, there's a lot of fear that partners will share this information or it will be used against them somehow, and may keep women in dangerous circumstances due to fear of violence, abandonment, loss of children, and potentially rejection and false accusations. Again, keep in mind that the majority of women who have been convicted in Canada for non-disclosure have been marginalized in some way. So I think I just want to wrap up that those of us who are working formally and informally in and around the public health system, that if we really want to protect those who are most vulnerable and reduce new infections, we need to do more to advocate for and enhance prevention, encourage testing and linkages to care, treatment, and support, and also to decrease stigma and misinformation. We need to do more to speak out against the Supreme Court ruling and help the public understand why it is doing more harm than good. And for those of us, not me personally, for those of you who are working in the criminal justice system or will be someday, either as attorneys or in the criminal justice system somehow, to not choose the criminal route when these cases come forth, and advocate for a more public health approach. Thank you.
Okay, so what we've heard so far, just to sort of pull it together before we launch into questions and make sure we answer your question, is that historically we've seen this, and continuingly, a gender divide when it comes to HIV/AIDS, and a failure to engage with the context, and to embrace in particular these strategies of health promotion as they've developed over the last few decades. Our most recent decision flies in the face of scientific knowledge about transmission and risk. It ignores public health knowledge about the best ways to support those living with or who may have been exposed to HIV/AIDS in their activities. We had hoped this decision, or many of us did, would clarify and change the law And instead, the hammer that was in place has been replaced by what I would call a steamroller, a much more aggressive approach, while continuing to punish those who know their status, right? That is very much a real outcome here. Undermining and stigmatizing, continuing to stigmatize those who live with HIV/AIDS. Some of the key points that we've just heard is that the public health approach, on the other hand, is a far more balanced one. It's more responsive to the reality that many women in particular who are living with HIV/AIDS are vulnerable. They are not necessarily in a position to exercise full sexual autonomy, and that a public health approach maintains powers of intervention that can be used in appropriate cases. Overall, I think we've heard from all of our speakers this consistent call that we have seen significant scientific progress in understanding HIV/AIDS transmission and containment. We have strong research out there supporting the conclusion that criminalization does not prevent people from engaging in behavior that could transmit. We've given a potentially very strong coercive tool for abusive partners, and we have some examples of that tool being deployed. And at the same time, we know that public health and health promotion strategies are effective. So our latest decision from the Supreme Court of Canada is absolutely a step backwards, which will quite likely lead to continued overcharging and the undermining of the good public health and public health promotion research that we have going on here. I'm going to just interrupt us briefly because I know that people may have somewhere they need to be shortly. We actually have the room booked until 2 o'clock, and so people are welcome to continue and come on down for a conversation. But just to capture your attention for those who do need to depart, first, on Friday, January 18th, Jackie Gahagan will be taking these issues further from a public health perspective, when she speaks here at the law school as a Health Law Institute seminar speaker. So marking your calendar. Secondly, International Women's Day is March 8th, as usual. And there's a number of activities in the works for that week to forefront the impact on the criminalization of HIV for women. And Jackie and Alex would be extremely pleased if people who are here today would like to join in on the planning committees or otherwise get involved in moving these activities forward. And currently we're, what's on the go is there's going to be a screening of the very powerful film Positive Women, and likely a cooperatively pulled together art gallery exhibit. So there's a number of, kind of fun things to get involved with, as well as educational and advocacy based. So please contact Alex or Jackie if you want to get on board. And that's the end of my little announcement, so you can continue the conversation.
Yeah, just hold on a second. So I put a sign-up sheet just over here if you want to write down your email. I can email you if you want to either volunteer for that event or just be informed more about it once we know more. Jackie,
Just save the date, yeah.
So thank you to Outlaw, the Del Feminist Legal Association, Health Law Students Association, South Coast Sexual and Gender Resource Center, formerly known as Del Women's Center, the AIDS Coalition of Nova Scotia, and the Nova Scotia Advisory Commission on AIDS, all of whom helped put together this event today.